Want to know how you can make a will in England and Wales? In this podcast, our hosts take you through the process of creating a valid will and discuss the administration of estates. They also cover the basics of inheritance tax. This material was put together by Dr. Yannis.glinavos. If you would like to know more about how this podcast was produced, get in touch with Dr. Yannis. I will now pass you on to our hosts. Thanks for listening.
Okay, I'll admit it. The whole writing a will thing, it's been one of those things I keep meaning to do, like adulting tasks that feel huge. But lately, it's really been on my mind. Problem is, I have no clue where to start. I've got articles, guides. It's all a bit much.
Oh, I hear you. That's so common. It can feel like you're wading into this legal swamp, But hey, that's what we're here for. Let's break it down bit by bit, and hopefully by the end, you'll feel way more confident about tackling your own will.
That's the dream. So, first off, legally speaking, what is a will?
Basically, it's a legal document. It lays out what you want to happen to your estate, fancy term, after you're gone, who inherits what, how you want things handled, all that.
Right, so it's like making sure my wishes are followed even when I'm not around to, supervise.
Exactly. And you, the person making the will, you're called the testator. Sounds kind of grand, right?
Testator, eh? Important stuff. But I bet there are rules, like who can be a testator, what makes a will actually legal?
You bet. Can't just scribble something on a napkin and call it a day. 3 big things for a will to be valid legally: mental capacity, intention, and formalities. All laid out in the Wills Act of 1837, the big cheese for wills in England and Wales.
Okay, let's unpack that. Mental capacity, what's that mean, practically?
Legally, it's testamentary capacity. Basically, you got to be of sound mind when you make the will. Understand what a will is, what you own, who your beneficiaries are, all that.
So, got to be clear-headed, no signing wills after a wild night out. Got it? What about intention, then?
Means you're making the will out of your own free will, nobody pressuring you, no tricks. What's in that document? It's got to be what you want.
So nobody can, force me to leave them my signed first edition Harry Potter collection or something?
Nope. It's your call how your estate's split up. Now, formalities, this is where it gets a bit technical. Wills Act, it's got rules on how the will's made and signed to make it official. We'll dig into that more later, but basically signing it right, with the witnesses, all that jazz.
Gotcha. So there's a proper process to make it all legal and above board.
Exactly. Now, back to mental capacity for a sec. It's not just knowing what a will is, it's also about not having any insane delusions, things that could mess with your decisions about the will.
Insane delusions. Okay, now we're getting complicated. What's that mean, legally speaking?
Think of it like a belief that's just plain wrong, demonstrably false, and it's affecting your will choices. Like someone thinks they're royalty, leaves everything to some made-up heir, that kind of thing.
Ah, I see. Got to make sure those decisions are grounded in reality, not some fantasy land. Makes sense.
Exactly. The court's going to look at evidence. Was the person, actually delusional when they made the will?
So mental capacity, it's a big deal to make sure the will is valid. When does that usually come up as a problem, in real life?
Often it's about the person's age, health, mental state. If someone's got dementia, big decline in their thinking abilities, that's when folks start questioning if they really understood what they were doing with the will.
So got to be aware of those factors. Make sure whoever is making the will, they're actually capable of deciding about their estate.
Absolutely. It's about protecting their wishes, making sure the will truly reflects what they wanted.
Now, you said before the executor is like the project manager, right, for the estate. What exactly do they do?
No, it's multifaceted. Kicks in the moment you pass away.
Right.
Think of them as the person making sure what's in the will actually happens. Gathering assets, paying debts, taxes, getting the legal paperwork from probate, and then finally distributing everything to your beneficiaries, all according to your wishes.
Well, that's a lot. So picking the right executor, that's got to be crucial. What should you think about when making that choice?
You're right. It's a biggie. Someone you trust completely, organized, dependable, good with finances, needs to be comfortable with legal stuff too, in case things get tricky.
So level-headed, good at navigating drama. Sounds like you're describing a saint.
Well, it takes a certain personality type, that's for sure. And don't forget, it can be time-consuming, demanding. So got to choose someone who's willing and able to step up.
Right. No springing it on someone as a surprise birthday gift. What if the estate's complicated, like multiple properties, businesses? Can you have more than one executor?
Absolutely. You can have a team. They can work together, makes things easier.
That's good to know, like a team of experts making sure everything goes smoothly. What about if you have kids? Little ones, I mean. Anything special about that in a will?
Oh, absolutely. If you've got kids under 18, your will should name a guardian. If something happens to you, they're the ones taking care of the kids.
Oh, wow, that's huge. How do you even choose someone for that?
Gotta be someone you trust completely,
Well,
obviously. Shares your values, parenting style, and of course they gotta be willing and able to raise your kids. Important to talk to them beforehand too, make sure they're on board, understand what you expect.
right, communication is key. It's not just a name on paper, it's a whole conversation, right? What about if a child has, special needs? Anything different to think about with the will then?
Yes, if you have a child with special needs, planning for their care, it's super important in your will. You might think about setting up a trust, manage their inheritance, make sure they're taken care of even when you're not there.
Makes sense. It's like customizing the will to fit, everyone's specific needs. You mentioned trusts earlier. Can you remind me, what's a trust exactly?
Sure thing. It's a legal setup where you, the owner of the assets, you transfer ownership to someone called a trustee. They then manage those assets, but it's for the benefit of your beneficiaries, following the rules you set up in the trust document.
So it's like having someone look after your stuff even after you're gone, making sure it's used the way you wanted.
You got it. Trusts are really useful for lots of reasons. They can protect assets, especially if a beneficiary is, say, too young, might not be responsible with a big inheritance all at once.
All right, so it's a way to make sure the money is used for the right things.
Exactly. And they can also help with minimizing inheritance tax or maybe providing for someone who wouldn't normally inherit under, the standard rules if there was no will.
Standard rules, no will. What's that called again?
Dying intestate. Basically, no valid will. Then these rules kick in. They're in the Administration of Estates Act, 1925. They decide how everything gets split up among your relatives.
So like a default system.
Yeah.
But it might not match what the person actually wanted.
You're spot on. That's why having some kind of will, even a simple one, is so much better than leaving it all to chance.
Yeah, that's a good point. Don't want my vinyl collection going to some random cousin I haven't seen in 20 years.
Exactly. Now let's talk about another big one. Inheritance tax. A lot of people get stressed about that when planning their estate.
Oh yeah, inheritance tax. One of those terms that just sounds scary. How does it work in a nutshell?
So, inheritance tax, or IHT for short, it's a tax on what someone leaves behind when they die. It's only on the value above a certain amount, currently £325,000.
So if it's less than that, you don't have to worry about it.
Exactly. And there are also things like reliefs, exemptions that can lower the tax or wipe it out completely. Gifts to spouses or civil partners, those are exempt. Same with gifts to charities.
So ways to minimize the tax hit. Got it. But what if your estate is worth more than that threshold? How's the tax figured out?
The usual rate is 40%, and that's on the amount over the threshold. There's a lower rate, 36%, if you leave at least 10% to charity, though.
So percentages based on how much is over the limit? Any other tricks for lowering that inheritance tax?
You bet. Giving gifts while you're alive is a popular one. Up to £3,000 each tax year, totally tax-free. You can also set up regular payments from your income, as long as you can still afford to live comfortably, of course.
So by giving things away strategically, you can shrink the amount that's taxable when you die.
Exactly. And remember the 7-year rule. If you die within 7 years of making a gift, it might still be taxed. But the longer you live after the gift, the less tax there is.
So it's like a sliding scale based on how much time passes.
Right.
What about gifts to your spouse, partner? You said those were usually exempt.
Yeah, those are usually fine, both while you're alive and when you die. It means you can leave everything to your partner and no inheritance tax to worry about.
Good to know.
Yeah.
So planning carefully, knowing the rules, that can really help with minimizing the tax impact.
Absolutely. And never underestimate the power of good advice. A solicitor or a financial advisor, someone specializing in estate planning, they can be invaluable.
Get expert advice. Adding that to my to-do list for sure. So we've done the basics, what a will is, who can make one, what needs to be in it. Anything else we should cover before we get into the really specific stuff about writing the will?
Yes. One more big one. The attestation clause. It goes at the end, basically confirms the will's been done properly, following all those formalities we talked about.
So like a final check, making sure everything's in order.
You got it. It says you, the testator, signed the will or acknowledged your signature if you couldn't sign yourself, and that the witnesses were there, saw it all happen, and signed too.
Okay, so it's a record of the whole signing, witnessing thing, proves it was all done by the book.
Exactly. Can't forget it. It's a vital part of a valid will. No proper attestation clause, the will might get challenged.
Right, so attention to detail matters, even down to that last little bit. This is all making a lot more sense now, feeling like I'm actually getting the hang of this will stuff.
That's great to hear. But remember, we're just getting started. Lots more to explore. But these basics, they'll help you tackle the more complex stuff with confidence.
Okay, so foundation's laid. Let's move on to the trickier stuff, like different types of gifts, what could go wrong, and all that inheritance tax planning.
Sounds good to me. Okay, so let's jump into some of that more specific stuff you mentioned. We talked about bequests, gifts, and the will, but there are loads of different types of gifts you can put in there.
This is where I start to feel like I need a diagram or something. Specific gifts, residuary gifts. What else is there?
Well, one interesting one is a class gift. Instead of naming individual people, you're describing a whole category of beneficiaries.
So like, instead of my niece Sarah gets this, it's more like all my nieces and nephews get that,
Yeah.
even if I haven't met them all.
Exactly. Really handy for big families, or if you just want to include everyone without listing every single name. But of course, clear wording is key here. Don't want any confusion about who's actually in that class.
Makes sense. Things could get messy if the wording is vague. What happens if someone, a beneficiary, they die before I do? Does their gift just disappear?
Nope. That's where a substitutional gift comes in. You can say what happens to that gift if the original person isn't around to receive it.
So I could say, if my brother dies before me, his share goes to his kids. Something like that.
You got it. It's like a backup plan. Make sure your wishes are followed, even if things don't go exactly as planned.
Okay, that's good to know. Like a built-in safety net. Are there other, unusual gifts people might include?
Oh, there are conditional gifts. That's where getting the inheritance depends on something happening.
Like my daughter gets the house, but only if she finishes med school.
Exactly. But gotta be careful with conditions that can cause headaches later. The court might have to step in and decide if the condition is, reasonable or even possible.
Right, so maybe not. My son gets the beach house if he becomes a pro surfer.
Haha, probably not gonna fly. Speaking of things going sideways, let's talk about will challenges when people try to fight what's in the will.
Oh, yeah, that's the part that always makes me nervous. You hear those horror stories, families fighting, ending up in court.
It happens, for sure, but it's not as common as you might think. Most wills are carried out just fine. Still, it's good to know why someone might challenge a will.
So what are the most common reasons for a will challenge?
The big three are usually lack of testamentary capacity, undue influence, and want of knowledge and approval.
Okay, we talked about testamentary capacity, right? Person making the will has to be of sound mind. What's undue influence then?
That's when someone pressures or forces the person making the will, the testator, into doing something they wouldn't really do on their own.
Like a sneaky relative talking an old person into changing their will to benefit them.
Classic example, but it can be much more subtle than that. Could be a manipulation, threats, even taking advantage of someone who's vulnerable.
Sounds tricky to prove. How does a court figure out if that happened?
Evidence, mostly. Was there a sudden change in the will? No good reason for it? Did the person who benefits from the change have a history of, controlling behavior? Was the person making the will isolated, easily influenced?
So it's like a detective case, looking for clues to see if someone was pulling strings behind the scenes.
You could say that. The court's job is to figure out if the person really made their own choices, freely and willingly.
Okay, and that last one, want of knowledge and approval, what's that all about?
Basically, it means the person making the will didn't really get what was in it. Maybe they didn't understand the language or someone lied to them about what they were signing.
So not just about force, but making sure they were informed, gave their genuine consent, right?
Absolutely. It's about protecting their right to choose, making sure the will truly reflects their wishes.
Okay, seeing how all this helps prevent things going wrong,
Yeah.
keeping the will honest, are there any, famous cases that show how these challenges actually work in real life?
There's a really interesting case, Wales v. Dixon, all about how important clear wording is. It was a fight over an apostrophe, believe it or not. The will said nephews and nieces, and they argued over whether that meant all nieces and nephews, including those by marriage.
Wait, an apostrophe? Seriously, that can change everything in a legal document.
You bet. The apostrophe, it was all about who was included. Blood relatives, or also the ones from the spouse's side. In the end, the judge said, include both groups. He looked at the guy's long marriage, close relationship with his wife's family, all that.
Wow. So yeah, every little detail matters, even punctuation.
Big time. It shows how important it is to have a well-written will, one that's super clear, no room for arguments.
Okay, definitely double-checking my commas and apostrophes from now on. But what if someone just doesn't have a will, dies without one?
Yeah.
What happens then?
That's called dying intestate. And when that happens, the rules of intestacy kick in. It's all laid out in the Administration of Estates Act 1925.
So it's like a backup plan, but one that the law makes, not the person themselves.
Exactly. It prioritizes spouses or civil partners, then children, then other relatives, in a specific order. But it might not be what the person would have wanted if they'd had a say.
Right, like a one-size-fits-all solution, which we know isn't always the best.
You said it. Having a will, even a basic one, is so much better than leaving it all up in the air.
Okay, definitely convinced on that point. Nobody wants their prized possessions ending up with some distant relative they barely know.
Exactly. Now, on to another important bit. Inheritance tax. A lot of people worry about this when they're sorting out their estate.
All right, we've covered loads already, wills, executors, all those challenges, even that scary inheritance tax. What's next on our list?
We've mentioned trusts a few times, but let's dig into those properly. They can be really useful in estate planning, give you lots of control and flexibility.
Okay, remind me again, what is a trust? And why would anyone want to set one up?
So a trust, it's a legal arrangement.
Yeah.
You, the owner of the assets, you're called the settlor, right? You transfer ownership to someone called a trustee.
Oh.
They manage those assets, but not for themselves. It's for your beneficiaries, the people you want to benefit, and they have to follow the rules you set out in the trust document.
Right, so it's like having a dedicated money manager, even after you're gone, making sure it's all used how you wanted.
Exactly. Trust can be really helpful, especially if your beneficiaries are young or maybe not so great with money, you know. You don't want them getting a huge inheritance all at once and making bad decisions.
Yeah, makes sense. Protecting them from themselves, in a way.
Exactly. And trusts can also be good for things like minimizing inheritance tax or providing for someone who wouldn't normally inherit if there was no will.
Ah, right, like a way to bypass those standard intestacy rules if you need to.
Exactly. Now, there are different types of trusts, each with its own purpose. For example, a bare trust is the simplest one. The beneficiary has immediate access to both the income and the capital, the actual assets.
So pretty straightforward. What other types are there?
Well, you've got discretionary trusts. Here, the trustee has the power to decide how and when the money is given out to the beneficiaries. More flexible, they can adapt to changing situations.
So they can make decisions on the fly. Sort of.
Yeah, exactly. And then there are interest in possession trusts. The beneficiary gets the income from the assets, but not necessarily the assets themselves.
So they get regular payments, but no control over the actual money or property.
Exactly. And then there are more specialized trusts, designed for specific things like protecting assets for someone with special needs or minimizing inheritance tax even further.
Wow, so many options. I guess picking the right type is pretty important.
Absolutely. You really need expert advice for this. Talk to a solicitor specializing in trust law. They'll help you figure out what's best for your situation.
Consult a solicitor. Definitely hearing that a lot today. But it makes sense with all this legal stuff. So we've got the settlor, the person setting up the trust, and the beneficiaries, the ones who benefit. What about the trustee, the one managing everything? What makes a good trustee?
Like with executors, you want someone trustworthy, responsible, good with money. But trusts can go on for ages, years and years, so you also need someone who's in it for the long haul,
So reliability and financial skills, definitely.
Yeah.
Can you have multiple trustees, like multiple executors?
Yep. Especially for complicated trusts or ones that'll run for a long time, it's a good idea to have a team. They share the burden, keep each other in check.
Well, it's a cross management board, right?
Exactly. And what happens if the trustee, they can't do it anymore? The trust document, it should say how to appoint a new trustee. You got to have a plan for that to keep things running smoothly.
Okay, so thinking ahead is key.
Absolutely. And what happens when the beneficiary dies? The trust document, it'll say where those assets go next, maybe to their heirs, maybe into another trust, maybe even to charity, depends what you want.
So it's like a chain reaction. The trust document controls everything, even after the beneficiary's gone.
Exactly. And make sure your wishes are followed, even generations down the line.
Okay, enough about trust. Let's move on to what happens when someone dies, how their estate is handled.
All right, what's that process like? First things first, you need a grant of representation. It's from the probate registry, and it basically gives the executor the legal right to deal with the deceased's estate.
So it's like official permission to start sorting things out.
Exactly. Now, there are two types. If there's a will, it's a grant of probate. No will. It's a grant of letters of administration.
Two paths, depending on the will situation.
Yeah.
And once the executor or administrator has this grant, what then?
Well, then they can start gathering all the assets, paying off any debts and taxes, and finally distributing everything according to the will, or if there's no will, according to the rules of intestacy.
So lots of paperwork, making sure everything's done right. Sounds complicated.
It can be, especially if it's a big estate, lots of assets. Executors often get help from solicitors, just to make sure everything's legal and above board.
Yeah. Makes sense to have an expert on your side during all that.
Yeah.
Are there times when you don't need this grant of representation?
Sometimes, yeah. Like if the estate is really small, just some cash, or if everything's jointly owned and it automatically goes to the surviving owner, then no grant needed.
So some simpler cases where it's easier.
Exactly. But usually that grant of representation is a must-have. Now, what if the executor named in the will, what if they can't do it or don't want to?
Yeah, what happens then?
Well, someone else, usually a close relative or a beneficiary, they can apply to the court to become the administrator instead.
So there's a backup system. Why might an executor not be able to serve, though?
Lots of reasons. Maybe they died before the person who made the will, maybe they're sick or just not up to the task, Or maybe there's a conflict of interest.
Like throws curveballs for sure.
It does.
Yeah.
But the system's designed to handle those situations.
Okay, I think we've covered pretty much everything. Wills, executors, trustees, inheritance tax, intestacy, even probate. Anything we've missed.
Feels like we've gone through it all. We have, but remember, estate planning, it's not a one-size-fits-all thing. What we talked about today, it's the general idea. But your will, your estate plan, it all depends on your specific situation, what you want to achieve.
Right, everyone's different.
Exactly. So get personalized advice, talk to a solicitor, they'll help you make the right decisions for you.
Seek expert advice. Definitely the main takeaway from today. And thank you so much for taking us on this deep dive. I feel way more prepared to tackle my own estate planning now.
Glad to hear it. Remember, taking control of your estate planning, it's a powerful thing. It makes sure your wishes are followed, gives you and your loved ones peace of mind.
Absolutely. And to all our listeners, remember, this is just the beginning. Get advice, do your research, and create an estate plan that reflects your values, protects your legacy.
Thank you for listening till the end of this podcast, and have a look around Dr. Yannis' channel for more information on key SQE1 FLK topics.